For pronouncement of judgment, item 11. Item 12.
Appeal stand allowed, consequently the petition filed by the one. No, obliged.
Adjournment request.
Item 9, my lord. The counsel for the BTC is out of station and seeking some accommodation. Item 9.
Adjourn. Pleasure. Come by. Another party,
My lord,
gentlemen, slip with the consent of that.
lordship, with the consent of the other side, I beg to mention item number 1. I seek some accommodation till 5th of June. Lord.
September.
Much.
The consent of that.
Lordship submission, I'm seeking some accommodation at number 3, my lord, for 2 weeks. I have to file a substitution petition. I have sent it to the department. Obliged.
Please, Your Lordship. Lordship, I beg to mention, with the due consent of the other side, I beg to mention item number 8, Your Lordship. Can this matter be taken up after 2 weeks, my lord? We'll be filing our additional affidavit. my lord.
Adjourn.
May it please the Lordship. Lordship, I'm sorry to be troubling you with this. May I make a mention for a listing of a review petition?
You can ask the registry. We have
Lordship,
already
the review
directed
petition
them.
was filed on 29th of March, and we moved an application for listing in April. We were informed that it will come in due course. It's been a month, and it's relating to ambulance services. So
No, so the review order of the
order of the review was of 23. We went to Supreme Court. There was a status quo order which protected us, so we're continuing. But now Supreme Court is dismissed, and the ground for review is we've come across documents which we did not know about, pursuant to inspection by the Supreme Court.
is the bench.
Bench is the then Chief Justice and Justice Mitali Thakuria. So I understand there's a challenge to constitution of a bench. Also, Lordship may just direct for a date, if we can get a date.
We'll ask the registry.
Lordship,
We'll ask the
the other problem is I'm in a precarious situation. Justice Nair was for respondent number 4. So it has to be oral by your Lordship.
It has to be, if the review petition is there, there's certainly one judge.
Yes,
was
yes,
earlier
that is what, yeah.
That is to
I'm just, I didn't want to not oblige.
Number 2 itu. Setiap kali.
Yes.
For hearing number 2. Item number 2.
May it pleases your Lordship. I was supposed to file an affidavit, so I had filed it day before yesterday, Lordship.
It is on record.
I had
It is on
filed-
record. Yes.
Lordship, in this new affidavit, I had brought in two documents, Lordship. But in the affidavits of the respondents, there is no exercise whether yearly survey they are making or not. How many beneficiaries and all that to their Lordship. And moreover, Lordship, they have said that 100% saturation in paragraph 5 of their affidavit. They have stated that 100% saturation under NFSA. They had made, Lordship. But as per, there is one, I would like to point out, Lordship. Government of India, they had stated that 30,000, they have additional allocation which they can make, Lordship. They have stated also in their affidavit. And there is nothing on record to show that as per this order, Lordship, 2015 order, that every year they are making survey, or they are or bogus ration card they are cancelling, or additional new ration card they are issuing. Nothing to say on records that they have done that exercise, Lordship. And in page 175, Lordship, Under Secretary, a letter was written by the Under Secretary Government of India, which is in page number 175, Lordship. Wherein it's in the first paragraph itself, Lordship, it is stated, however, the state government has so far covered only 8.4.
Which affidavit you are referring to, of whom?
This affidavit is filed by respondent number 2, Lordship, as per order dated 27, page 175, Lordship.
175.
Yes, Lordship.
This affidavit was filed when?
It was filed,
2022.
yes, Lordship.
Yeah.
Wherein the address in that annexure 6, Lordship, page 175, first paragraph. However, the state government has so far covered only 8.40 lakhs, thus leaving around 30,000 people in the state for whom Government of India has allocated rice at the rate of rupees 3 per kg.
Yes.
So 30,000 additional there, it's their
It was
Lordship.
in 2022, ma'am.
But they have not brought on in a record any documents, whether every year whether they are doing that exercise, which in our additional affidavit, which we had filed on 29/4.
Come to your reply. Come to your prayer of the petition.
Yes, Lordship. Survey of entire, the first prayer is there.
Read.
Yes, Lordship. Issue of writ of mandamus directing the respondent, Food and Civil Supplies and Consumer Affairs Department of the Government of Arunachal Pradesh authorities to conduct a survey in the entire Changlang, Namsai and Papumpare district to identify poor household under the target public distribution system who do not have ration card, and to issue ration cards to them, and during the course of the survey invite application from such household through rigorous advertisement, Lordship.
Next.
Quash the impugn notification or circular dated so-and-so of the 31st October 1991 banning ration card to Chakmas and Hajong issued by the Circle Officer Daim and Bordumsa subdivision in the district of Changlang Arunachal Pradesh. Issue a writ of mandamus directing the respondent with Food and Civil Supplies and Consumer Affairs Departments of the Government of Arunachal to issue ration cards, inviting application from the villages of Changlang, Namsai, and Papumpare district expeditiously in a time-bound manner, dispose of the application of ration cards. Issue of writ of mandamus to the government of our concerned authorities to provide nutritious food door to door, which at this point it's not, but Anganwadi centers, because with this we had filed a long back ago.
Come where.
Yes, door to door to all the children of poor and marginalized family, even who do not have access to Anganwadi centers. Issue a writ of mandamus to the government of Arunachal Pradesh and concerned authorities to sanction adequate Anganwadi centers in villages of Changlang, Namsai, and Papumpare districts. Issue a writ of mandamus to the respondent authorities to provide food grains under the National Food Security Act 2013 to poor households who do not possess ration card until and unless the ration cards are issued to them.
So how many players now are satisfied?
Lordship, as for now, we have applied, we have shown data, and there are more people. Yes, Lordship.
How many players have been satisfied? Ultimately,
Only paragraph 6, Lordship. Prayer number 4, Lordship.
4 has been now satisfied.
Yes, Lordship.
Okay. Now, what is the reply of the concerned department regarding the other prayers?
Lordship, as per the Honorable Court's order, they are providing to two communities of people ration only to the voters, Lordship.
Okay.
There are children of those voters, they are not receiving.
Okay. Now come to the reply of the state government. Yes.
Second, they have not speaking.
Have you have not gone through the brief, madam. It was
Yes.
listed for hearing.
Yes, Lordship.
So
I,
you have to be,
Lordship,
otherwise how will you
yeah.
assist the court?
yes, Lordship, I apologize. I thought that my affidavit was not on record, so
It
these
is
are the,
already on record.
so these are the reasons, Lordship, I need some accommodation so that I can assist Lordship.
At least
Yeah,
when
in
the
that.
matter is listed for hearing, you should.
Because I affidavit I filed only day before yesterday, so I thought that it was not on record.
There's some time to prepare the matter, to prepare and argue the matter. It's in September.
Deeply obliged, Lordship.
Item 4 and 5.
This is the pay parity message, Your Lordship.
Who is advocate, who is appearing for the this High Court? You're appearing.
Yes,
What
Lordship.
happened to the new proposal sent to the government?
Lordship, as of now, we don't have any instruction from the
When
registry.
you have sent the new proposal?
Lordship, to the best of our knowledge, Your Lordship, was sent on 24th of February, Lordship, 2025.
Lordship,
He is giving the information. What about you? You are for the High Court. You are supposed to give the information.
yes, Lordship.
Who is appearing for the government? Who is counsel appearing for the High Court? You are appearing.
Yes,
You are
Lordship.
the advocate for the High Court.
Yes, Lordship, on behalf of Mr. HK Das.
Who is Mr. HK Das?
He's on legs in court.
Call him. What about the proposal? When you send the proposal, where is the proposal? You give us the details
Lordship,
or seek instructions.
Lordship,
Without seeking instruction, don't appear in the court.
Lordship, after some time.
Pass over for the time being.
Item 6 and 7.
Also, we have filed the additional affidavit and Mr. M.K. Chaudhary last, evening I
Yes.
met him, need the instructions.
Yes, Mr.
Yes, my lord. Query was posed before the IOCL. The query was posed before the IOCL
Yes.
on the last
In
occasion.
your affidavit,
Yes,
in para number 11,
yes, my lord.
you offered some land. Now, at that time, as per you, they have not accepted that.
Yes.
Now they are ready to accept it.
No, but now our stand, your lordship, the entire construction in the area, we've obtained instructions from the IOCL. The instructions are with us. It has been categorically stated that no land can be released now.
No?
No accommodation, no, the stand which was taken in the affidavit prior, your lordship. The construction thereafter had completed.
What construction has been completed?
Your lordship, is a part of the boundary wall has been completed, my lord. It is at page 144. It's a submission. So the
But
boundary
Now,
wall.
now, this is not acceptable.
Yes.
You can't have this land altogether cornered or encircled by your land, and he'll not be able to
I
get
understand.
use the land.
I understand the concern, my lord. In fact,
Understand the concern, you have to make a way out. Either you acquire all the land or give them away.
possibilities.
A person can't be,
No, I understand. Yes.
he can't be restrained from enjoying the fruits of the property. This is high enlistment and nothing else.
No, absolutely. I understand, lordship, your lordship's query and the point of concern also. If your lordship,
Okay, then call your officer. Who is the officer here, main officer? They'll ask him. This is not the way.
no, we'll try to find some.
You can't treat a citizen in this manner.
No, we'll try find a middle ground, your lordship.
When?
Lordship will fix the matter next week. we'll take this lordship's query.
Okay, we are fixing it on sixth.
Lordship, eighth,
Come with a specific proposal, yes.
on eighth, Lordship, because I last occasion I told that I will.
Sixth,
Fourth,
sixth,
seventh, Lordship, if permit.
sixth. Okay. Pursuant to the direction given by this court on 22nd of April 2025. An additional affidavit is filed on behalf of the respondents wherein it is stated that they are agreed to accept the proposal as it is, as suggested, accept the offer as it is given by the IOCL as mentioned in para 11 of the affidavit in opposition filed on behalf of the IOCL in writ petition number 5956/2016. Full stop. Counsel appearing for the IOCL seeks time to complete his instructions list on 6th of May. Complete your
Yes,
instructions
we
and
will
come with the
yes,
proposal,
yes.
yes.
Item 10.
Respondent. এইবিলাক পিছত টাউনৰ কণ্ট্ৰিক্ট এক্টৰ পৰা সেকশন 15 to 53 to 57
It's okay.
apartment 22.
Yes,
Happy a lot. My lord, in this case, the writ petitioner was serving in the Jorhat Development Authority, which is an autonomous body, not a state, as therefore he was not holding any civil post under the state. Now, when subsequently, my lord, in 2009, he was appointed pursuant to a recommendation by the Public Service Commission, State Public Service Commission, as an engineer, junior engineer in the Assam Town and Country Planning Act. He filed an application seeking pay protection. Since it was not given by the state, he came before the Honorable Court. And the Honorable Single Judge has held that since in section 57 of the Assam Town and Country Planning Act, it is mentioned that, and the Lordship may kindly see at page 16, that is the basis for granting with a pay protection, my lord. Page 16 of the judgment, my lord. I'm sorry, 15, page 22 of my memo of appeal, page 22. May I read that paragraph, my lord? Page 22, para 15.
yes,
The learned counsel for the petitioner has referred to certain provisions of the Act of 1959 regarding the constitution of the authority, grants, advances, loans by the state government, and also audit by the Accountant General Assam, and also to section 57, as per which the officers and staff of the authority would be deemed to be public servant within the meaning of section 21 of the IPC. This court has further noticed that under section 8B, the composition of the authority itself had been laid down, which would show that all the members of the authority are to be appointed by the state government, and most of them are holding substantive posts under the state government and are ex officio members. FR 22 is with regard to pay protection. And FR 22 presupposes that the person should be holding a civil post under the state in his earlier appointment. And here, admittedly, he was not. And there was a reliance was placed on a judgment passed earlier by a single judge of the Honorable Court, where, my lord, only for the purpose of pension, his past service was counted, and this issue was never involved. My lord, I could not find any Supreme Court judgment, but there are two High Court judgments where this point has been dealt with. My lord, this judgment, Lordship, statement go to para 14, the last but one paragraph. Para 14. The pleaded facts would clearly demonstrate that the case of the petitioner is not a case of transfer from one cadre to another cadre, wherein such a pay protection under FR 22 can be claimed, which appears to be the sole purpose of FR 22. Both the posts and cadres in which the petitioner are appointed are distinct, separate, are of different cadres, and praying for appointment in the post. The petitioner made separate applications, and she was subject to appear in a separate recruitment process. However, the state government, in its own wisdom, being a welfare state and a model employer, has considered the past service of the petitioner for the purpose of pensionary benefits only. By taking aid of such a gracious attitude, the petitioner is not entitled to claim as a matter of right to get her pay protected as sought for. Now, there is one more judgment, which will be 2017 ACC Online Jharkhand 482, my lord. Paragraph 4, Lordship may kindly see, my lord. The petitioner, who was initially appointed in Samast Sant Middle School, so-and-so, on so-and-so, was subsequently selected by the Jharkhand Public Service Commission for appointment in a government school, namely Primary Jharkhand so-and-so. The petitioner took up the new appointment on so-and-so. The learned counsel for the petitioner has referred to the relieving letter issued by the Secretary of the Samsat San Middle School to contend that the petitioner worked as a primary teacher continuously from so-and-so, and while so, he is entitled for pay protection and seniority. I am unable to accept this contention letter dated so-and-so is not applicable in the case of the petitioner who was previously appointed in a minority run school, which obviously was not taken over by the government. So if FR 22 presupposes that the person should be working as a government servant, and subsequently, if there is a change in the cadre and he goes to a different cadre under the government, then only the question of pay protection under FR 22 1A, 1 FR 22 1A2 will come. Lordship, may I kindly see FR 22 for a moment when I'll show it.
Yes,
FR 22 starts with the sentence, the initial substantive pay of a government servant who is appointed substantively to a post on a timescale of a pay is regulated as follows. One, if he holds a lien on a permanent post other than a tenure post or would hold a lien on such a post had his lien not been suspended. One, we can skip, this is in the case of a promotion. Two, Lordship will kindly see. When appointment to the new post does not involve such assumption, he will draw as initial pay the stage of the time scale which is equal to his substantive pay in respect of the old post. I'm just reading one for a moment, my lord. When appointment to a new post involves the assumption of duties or responsibilities of greater importance than those attaching to such time scale next above his substantive pay in respect of the old post. And what happens, my lord, on his new appointment from one department to another department, if there is a question of any new assumption of new duties and responsibilities, then he will get 2 more increment for the purpose of fixation of his pay in the new scale. Now it is payment, my lord. If there is no question of assumption of new duties and responsibilities, then it will be equal. It is on the basis of this principle, my lord, that a pay protection is granted to an employee who in the case of a change of cadre, his pay in the earlier post is to be protected. So that being the position, when in this present case, it was a fresh appointment on the basis of a recommendation by the APSC. There was no question of a change in cadre. And his earlier appointment was in the under the Jorhat Development Authority, which is an autonomous body created under Section 8A of the Assam Town and Country Planning Act 1959. That being the position, my lord, in my humble submission, the judgment passed by the Honorable Singh Judge is erroneous, my lord.
despite service of notice, no one appears on behalf of the sued respondent. So, we have heard the arguments concluded, argument concluded, judgment reserved.
Deep down. Hold on. Obliged.
And then do
Pass over matter 4 and 5.
the respondent number 2 is the performer respondent.
We have sent a proposal on 24th of February, Lord.
Who is for the state? Who is for the state?
Legal. Oh, it's it has been sent to the judicial department, Lordship. Yeah, it's for the judicial department.
Lordships grants me a week's time, my lord, I'll obtain instructions on this.
This is too much. 24th of February, 2 months have passed and you have not taken any decision. What is this?
Please, sorry, my lord.
The matter is, the controversy is regarding the upgradation of the existing pay
Pay
structure of the
structures.
members of the E-Court
Service.
court services serving under the Guwahati High Court and the district courts, E-Court in bracket recruitment and promotion bracket close service rules 2015. Full stop. It appears that earlier the High Court has recommended upgradation of the existing pay structures of the employees of the members of the E-Court serving under the Guwahati High Court and the district courts wide letter dated 8/10/2018, but the state government has
Yes,
not
I'll do the.
accepted the same and raised certain objections.
Ready.
Stop. Now, a fresh proposal is sent by the Guwahati High Court on 24th of February 2025 to the Judicial Department. However, till date, however, the respondent, concept of the respondent Judicial Department is not in position to make a comment regarding the new proposal sent by the High Court on 24th of February 2025. Stop. She prays for a week's time to complete her instructions. Just after a week.
Deeply.
Yeah. You are for the finance department. The copy of the fresh recommendation sent by the registry of the High Court by the order dated 24th of February 2025 is already sent to the finance department of the government of Assam. The counsel for the finance department is also directed to complete his instructions in that regard. List on 8th of May. Complete your instruction.